This is Professor Dr. Jan Engberg from Aarhus University. He's a professor of knowledge communication at the Department for Language and Business Communication, Aarhus School of Business and Social Sciences at Aarhus University. His educational background is that of a specialized translator and text researcher. The new German term, Schreibwissenschaft, isn't that nice? And he works with the relation between language and specialized meaning in the field of law. He's especially interested in explicitly vague formulations in legal texts. So the jurists are suffering from them in general and say, oh, we have to avoid them and liquidate them. For example, sufficient cause in the interpretation of the law in courts and elsewhere, and in the role of the way of statute is formulated in this context, but also in the intelligibility of legal texts. You studied legal knowledge as represented in legal texts, and my basic assumption is that this knowledge is created in and influenced by an idea of communicative interaction. So a sociological concept in the end. You will demonstrate what is interesting in legal linguistics, especially from 2 points of view, partly as a venue for describing the influence of language on how knowledge and meaning are developed in the field of law, and partly as a possibility for investigating how knowledge and meaning develop through conversation and interaction among experts within a scholarly field. I quote from his own description, and to make not too many thoughts. As to the influence of language, the starting point of his many projects is particularly the legal texts and the way they are formulated. So the research areas language and communication, language and cognitive, functional and cognitive linguistics, language and communication in the direction of knowledge communication. So I would like to read the list of publications only for the last for the last 2 months. But as this would take too much time, it is really some. I have pages and pages. It's only 2:17. It's incredible. Not in order to ridiculize this, I have at least to say something. You may say this is just an invention, a rhetoric gag, or whatever. It is not. For example, the multimodal bridge between academics and practitioners in the Harvard Business Review's digital context, or das Dialog-Konsens-Struktur-Legegespräch als Schreibprozessforschungsmethode. This word is so wonderful, and the German language allowing for those Begriffskomposita, sometimes at least makes Germans proud of her language, and Weber made use of that by building notions as Gemeinsamkeitsglaube and other things that are very difficult to be translated. However, no claim on language as a privilege for knowledge, certainly not. Thank you very much for having joined us today, and we are looking forward to listening to a long period of experience in this difficult field. Thank you very much for being with us.
Thank you very much for Dane from of humble origin. It's somewhat I blush by that kind of but actually it is correct. 2017 I think was the most proliferous year I've had, but it's also sensible to, it's also relevant to say that the reason why I can publish as much as I can is that I love working together with people, and they write it and I'm just on it. So that's about that. I was very happy when I received the invitation to participate in this Journée d'études here at the Center for Law as Culture. As you say, as you've seen also when you browse through the titles, my research so far has not nominally occupied itself very much with the concepts of culture. It's actually not. You can say culture as such has been on the verge of what I've been doing, but I wouldn't classify myself as a cultural researcher or a researcher of culture. But at least it is my opinion that my work on communication of legal knowledge in expert as well as non-expert settings is close enough in its ways and procedures and objects for me to learn a lot of interesting things from discussing language and law with you. And I've already tried to dive into some of the writings from the center, and I found out that it was correct. I could really learn a lot from that. And if I'm lucky, then the same applies the other way around. We'll see in the course of what we're doing here. Over the years, I've studied legal communication from a textual and linguistic point of view, especially. In the first many years, I concentrated upon expert texts with performative character, like statutes, judgments, contracts, and that has to do with the fact that I'm trained as a translator, and I still train legal translators. So that was, so to speak, the first thing I had to know something about and had to be able to work with. So in that way, it worked out. In the latter years, I've gained interest in non-performative legal texts like law journal articles, and also texts mediating the legal knowledge of to non-experts. So, meaning we as a legal institution want to mediate, to convey the knowledge that we have to somebody else. And today's talk will concentrate on this topic. Taking mediation communication of the Court of Justice of the European Union as an empirical example. I'm not going to dive deep into that, but just as a linguist that is used to work with texts, I need something to hang on to, and that is then the hang on to thing for me, so to speak. In my mind, this could give us access also, I think, to describe some of the characteristics of the legal culture underlying the court, because you can say something about the culture by the way you mediate knowledge, and you can say something about the culture by what you actually choose to mediate, what you think is relevant for somebody else to know something about. I'm going to try to do a little with that, and I'm excited to see whether you agree with me on this and whether it would be possible. So I will say something more later about the knowledge approach. As you say, the title of my position is knowledge communication. As I'm professor of knowledge communication, I'll say a little bit about the knowledge approach and what it is. And it is an approach that we've been working on over the last 10 years together with colleagues in Aarhus at the university there, as a way of dealing with domain-specific communication. That's what we want to say something about. But instead of saying something about that now, I would like to begin by saying something about the object that I study, and then go into that, and then go on from there, so to speak. So it's also that is also a mediation trick, to not start with the abstract, but to try and make it somewhat concrete. Try to make it more concrete, at least. I'm not good at that, but I'm learning, so to speak. The communication approach I work within has its focus upon the communicative purposes pursued by standards of communication. We have in that way a fairly pragmatic approach to language and to communication, saying if we have communication in the field of law, for example, then it must be because somebody wants to do something with what they want. And especially because many of the types of communication we have here are done by people in pursuing their professional life anyway. So in that way, it's sensible to say something about it, and to presuppose that is one of the interesting perspectives to put on the kind of communication we see here. Therefore, I looked into. I've copied here some of the introductory things, introductory sentences from a leaflet of the European Commission as to why they think it is sensible to write legal and other official documents in an accessible manner. So you can say this is a small leaflet of 20 pages, I think 30 pages maybe, that is used for introductory purposes and for teaching purposes by the European Commission when they get new people or when they think they need to re-educate the people they have inside their group, so to speak. So they say you should write clearly. You know that idea from all over the place. It's a commonplace in all inside and outside of the legal field. Legal texts are very, very difficult to understand. So we should make them clear. That's a commonplace, so to speak. Why should we do that? Because that makes it that makes it easy to possible to work more efficiently together. One. Secondly, we should. It can, for an administration, it means that you can then reduce unnecessary correspondence because people don't need to get back to you and say what do you actually mean. So that means that you don't have to write the second letter. You can write the first letter, and that works. And then they say it's in order to build goodwill, and that's the one I'll cling on to today. What this means is that obviously also the European Commission thinks that communicating accessibly can be seen as a way of creating goodwill and thus influencing the image that you have. So it's a part of saying we are something special, but we will actually talk to you, and the way we and by doing that we hope that you will then get a better picture of us. They will not see us as negatively as such. In the field of language and law, this insight, the idea of having to use clear language and to communicate in a clear way and an efficient way and so on and so forth, has generated two different ways of tackling the problem, so to speak. You can say that one of them is more textual. That's the textual approach. That goes towards focus upon what the text writer can do in order to make her text more accessible. Say, what can I do so that my text gets accessible? That's, so to speak, the approach. I think this is the traditional way of working with legal language. I can see it in Denmark. Every time we get a new minister, then the first thing he does after 2 weeks is he sends out a press release saying, from now on, in my ministry, we're going to write clear texts. And the next one, 6 months later, does the same. Because the idea is this is really a good thing to say, and it lives up to an idea saying you can, if we improve the texts, then things get more accessible and more understandable, and that's a good thing to have a clear and easily a transparent administration, so to speak. The other idea, the knowledge approach, that widens the scope. It doesn't limit its focus to the text, but focuses upon the process of the knowledge construction by the receiver, leading to her understanding of the message communicated to her. So instead of just saying it's a question of making the text so that it carries the message in the right way, it tries to widen the scope and say, wait a minute, actually, that's not understanding is not in the text. Knowledge is not in the text. Knowledge is always up here. So something happens up there, and that is the relevant thing. Text and its accessibility plays a role here also, but it is only seen as so to speak the trigger of the process that runs the process of understanding. So in this view, what is very important are the knowledge structures that exist already before I read a text. What do I know already that I can combine with what I get in? Because that actually is probably the decisive thing about actually understanding something in the way that the sender wanted it to be understood. Whether this kind of combination is possible. I'll get back to that for most part of my presentation, and also that was one of the reasons why I came to start to work more with these texts that are directed towards the general public instead of just looking at the performative text, because they are part of actually I think a process that you have to do from the side of the administrations in order to perceive a better understanding of what they want to do. But if you look at this comes from a seminar that I just participated in not 2 weeks ago in in Tallinn, in Estonia, where we looked at text quality. The title of the seminar was how to achieve better text quality. And what you get there is then a focus on text quality, especially on legibility and readability, so to speak, font size, colors, quality of print. How do I make my text accessible from that point of view, and also from the point of view of readability? What words do I use? Are they commonly known? How long are my sentences? How complex are they, and so on and so forth. So these two are very much oriented towards getting that idea through, to say, how do I make a good text? And for that, we had presentations there on drafting procedure, on focusing of formulation, on managing terminology and things like that are all directed towards how do I make a text that is efficient, so to speak, that can actually achieve what it can. But, to me, to my mind, the actually important point is to go one step further and to say we want to achieve understanding. In order to achieve understanding, we need to widen the scope. Especially, we need to adapt to receivers, and that's naturally a problem when we talk about performative legal texts. Because how can you make a text that is thought of as targeting the whole group of citizens in a country with all their different conditions and prerequisites, and then at the same time say, and I want to target all of them, and I need to adapt to the receivers. That doesn't fly, and that's naturally the reason why administrators tend to go back and say, okay, I'll do this, because this I can do. It's difficult to do it, at least on the basis of the text. You need to do something else. You need to get away from the idea of saying the text alone is what is relevant here. There has been a very interesting, I think, project running for a number of years in Britain called the Good Law Project. Carried by the administration there too, where they've worked with some of the same ideas, and they have actually gone the extra mile to not stop where people normally, or where projects and administrators normally stop. Maybe to stop at this place and say, now I have a text that is effective. I know exactly that it is accessible. You can work with it. I can understand it. Thus, this is a good text. And then say, what we're actually looking for is efficacy. It is regulatory efficacy. It is, do my regulation actually work? Is it, do I achieve that people understand what we as legislators want them to do? Do they know what their rights are, and so on and so forth? So they've done some checking actually, very very unusual, and it got very silent at the seminar in Estonia among all the administrators when I said you could actually check whether people understand what you write. And someone then came out, could you give us citations as to references as to where we can read about that? I said, yes, we can look at that. But it's telling, I think, that we tend to stop here. Also, I think actually that has something to do with the legal culture. That the legal culture is very much oriented towards, and has very much this idea of saying law isn't the text. So we just have to work with the text, and then it's okay. And I've been saying these things for a long time. Some lawyers also get to accept what I say. Many lawyers just start talking about something else when I say, a text doesn't carry meaning. They just say, okay. And let's talk about something else. But the idea there is then, that led us, so to speak, and has been developed. This approach and idea has been developed in connection with this knowledge communication approach that we have been working on in Aarhus. It has two different foci. One focus is the one which comes up here first. It says that we look at the communication among experts, or communication of knowledge of experts to other experts or to non-experts, as the communication of knowledge which is at the same time individualized. You can say I carry knowledge, and it's at the same time it is something which is you can say the idea behind this is to say that knowledge empirically only is present in individuals. The only place I can go and find knowledge is talking to somebody, because knowledge is only up here. There's no knowledge floating around. Knowledge is only there. But at the same time, that doesn't fly. The idea is not to say we all have knowledge and there's nothing we share, because we do share knowledge, because we have this collective idea of knowing that others also know the same, and that strengthens my knowledge, and it's part of my knowledge that I know that everybody else also thinks of things in the same way. This idea of studying knowledge as individual and collective creates a space for the individual human being and her communication as an important object of study. Because by talking about knowledge in that way, we cannot just do abstractions and just say we look at what is floating around in society. But we always have to go back and say what does it look like in texts and in the minds of people. This teams up nicely with one of the basic tenets of the work of in the Danish research network Reline, on legal linguistics that Annelise Kjær, who's also here, was the leader of between 2011 and 2013, and which has also shaped my thinking a lot. In the network there, we developed the object of study of legal linguistics as being the combination of linguistic in a very wide sense, of legal perspectives and of context perspectives, seen as you can say three bubbles that overlap in some ways. Cultural aspects as a value-laden concepts belong here in the context perspective, in my view, in this. And in the intersection of these three aspects, we find the individual as the spot where all the perspectives come together. You can say, if you take a person and look at this person and his or her communicative interaction, then there you have the influence of the context, the culture, of the law and of the language and the linguistics and what goes on there. And that was the way we tried to say what could be an object of study of legal linguistics. And there it helped me a lot to work with this idea of saying knowledge can be both. It can be both something we share and is something that at the same is always at the same time something I share and something I have. In this way. The other aspect, which is more relevant today, is the idea of saying that knowledge communication has also in it the idea of a knowledge asymmetry. Meaning, we look at the coping with knowledge symmetries, that is, the communicative consequences of differences between individual knowledge, in depth as well as in breadth. So that is, so to speak, the starting point. And in that connection, popularization, which I've been working with over the last time. I have to find another word for it because I can't pronounce it. The pop word, so to speak. Popularization is one example of that kind of communication. It is communication where you start out as a communicator to establish, to pose, to demonstrate, and to say that there is a relevant knowledge asymmetry. I know something that you don't know, and you need to know it. So now we get to communicate. It's important to say that that the way we work with it, these knowledge asymmetries are established. They may be there anyway, but the idea is through communication you tell the person you interact with there is something here which is relevant. It's focused. We're going to talk about this, and we talk about it because I know something that you need to know, and I'll help you to get here. Second aspect is, in order for it to be popularization, you need to go outside your field. I would think that what happens in court, for example, when you interrogate somebody and you may try to explain some of the law that lies behind, that would for me not be popularization, because the idea is still to be inside the context that you're in. So you have to recontextualize it and want to do that. Then you want to present the knowledge, to say I try to give you the knowledge, and you need to try to actually make it more accessible. We'll get back to why I think it's relevant to make this distinction. because I think when we look at what is being done in many cases, you don't necessarily you might get until here. You don't always get until there in these things. This is to some extent to be seen. This is I think to be seen as a scale that you often have this. And then you can also have that, and also have that, and also have that. So it's thought of as kind of a scale, and in which only if you have all four intentions realized, you actually really have popularization. Otherwise, you have other purposes, other things going on. So in order to that was that. In order to look at that, I've just now isolated two indicators that I think could be relevant to look at from a linguistic point of view. One is the importance of terminology, saying to what extent do I try to explain the terminology I have? To what extent do I just use it without explaining it? And second is the so-called level of explanatory depth, which is which I'll get back to explaining in 30 seconds more or less. And you can say the question that we have here is, to what extent does the institution expect receiver to approach its knowledge level? So is the idea, I want to tell you something in order to get you closer to knowing what I know? So seeing this is kind of a process where I try to get you to get still wiser, and then thus know all the time more about what's going on here. And to what extent is it just a question of saying, there isn't a symmetry between the two of us. I know and you don't, and now you know where it is. You know where the difference is. But I don't want you to come over here. I just want you to know that here is the border between us. I've been working with this. This also demonstrates, I think, some of the things that I tend to do, which is not always wise, but I can't not do it. Namely, I keep on looking for things that could be relevant or could be useful for me in some way. And this is actually one of the approaches. And it's an idea that I encountered when I visited you, Larry, in Brooklyn 10 years ago. Yeah, 10 years ago, 11 years ago actually. Namely, the idea of illusion of explanatory depth. The idea here is that it shows that we know, and it's possible to demonstrate, that human cognition works with less than full complexity in knowledge structures. Meaning that I don't know exactly how the shifting of the gears on my bike works. I know that I don't, because every now and then I try to mend it, and it never works because I can't find out the system. So I don't know. But normally, if people would ask me, do you know how the gear shifters of your bike works? I would say, yes, I know. Every time I push this button, it shifts the gear. So I know what it is. And the idea, and that means that we don't, so to speak, we don't have the full theories of everything that we work with, but we have theories that are deep enough for us to work with it, so to speak, normally. And we actually are quite content with that. That is what is called the illusion of explanatory depth. That has been demonstrated empirically in different ways. You can train people so that they know how to make they know how to assess the level of technicality or of complexity of their knowledge, and then you ask them, for example, do you know how a helicopter works? Yes, I know how a helicopter works. Do you know how a helicopter hovers? And yes, I know. Would you say you know it well? And people would normally say, yes, I think I know it well. Especially if they have a picture lying before them, they would say, yes, I know it fairly well. If you then ask them, how is it that it hovers? What is it that makes it hovering? Then the most of us, me included, would say, no idea. I know there's something with the rotor, but why? What happens that makes it hover? I don't know what it is. And the trick is, it's an illusion of explanatory depth. We tend to think that we know things better than we do, until we are confronted with the situation in which we actually know, okay, this is not the case. I know it. When I heard about this the first time, I recognized what happened when I had been reading for class as a student and came, and I thought, I've understood this article. And then the professor asked me a question, and I said, no idea. Could I read it again, maybe? And that is this, so to speak. What I use it for, this is just the basis for it, so to speak. What I use it for is on the basis, or in connection with this, they have worked on a scale of complexity of explanations. And I can use that to try and say how complex is the explanation that is given of the thing that we're talking about. The first level you have is so-called causal relevance. Properties that are you are told that the properties matter causally, but you don't get any details. For example, European Parliament, European Commission, and European Council are institutions of the EU. So you know they're institutions; they have an institutional cause. You have no idea who does what, unless you are told, or unless you know beforehand. But on the basis of just this presentation, you only know they are related and they have a causal relation to each other, and they have a causal influence on something. Causal powers is the next step. There you have notions of the particular causal role of a property, but no details on the underlying mechanisms. That's more or less where I am with the gear shifters of my bike. I know what happens when I push the button, but I don't know exactly the mechanism lying behind it. Example here would also be the Court of Justice of the European Union. This is the judicial institution of the European Union. So you know what kind of relation it has. It has the function of being judicial power, so to speak. So you know a little bit more about it, but you don't know how does that come about, on what basis is that working, and so on and so forth. And the next one would be causal relations. And the important thing here is the idea of systems. You have a system, so it's not just this influences that in this way, but it is this influences that because there's an underlying reason of something, or these four things influence each other and build up a system that has something in it. And the example here, we'll get back to the example later. To ensure the effective and uniform application of European Union legislation and to prevent divergent interpretations, the national courts may and sometimes must refer to the Court of Justice. So that is giving the basis of why must we do this. So it is, you can say there's a causal relation between the Court of Justice and the national courts, and there is something lying behind it to saying why should they do it? It's because we want to ensure effective and uniform application. So that, in my mind, this would be a more complex explanation than the others. And the idea would then be to go about this and use it looking at different texts. I've just selected out two texts. One text is this one. And actually, both texts are at the same website. This is the website of the Court of Justice of the European Union, and this is the presentation of the Court of Justice, where they have a foreword and tell something about the construction that is going on, and then somewhere down here they tell something about various types, which is this references for preliminary rulings. That is the text that is being relevant here. I just we just say a few words about the website as such. As you can see, this is very text dominated. It's the same as we've seen before. They rely on the spoken or written word. They have a little bit of illustrations. That is actually the illustration on that page at all. What do they illustrate? They illustrate what you've been working on. They show the courtroom. No people. The only places where there are people is when you go in here in the members. Then you have a list of the members with everybody shown, and they're all in the same red robe. So they look very much alike, but then at least you have a face of somebody. But actually, that's what is there of people. Apart from that, it is describing systems and working in this way. What I've made red here is, for me, the second level, that is the level of causal powers, of saying this is relevant for that, this has influence upon that, and so on and so forth. And I have this slide, and the next covers what is said about the references or the references for preliminary rulings. As far as I can see, the main point and the only real point where they actually give some more background kind of explanation, more at the system level, is this one. Apart from that, it's just saying this has an influence on that. This has the power to do this, and so on and so forth, but not explaining any kind of system around it. Looking at terminology, you can say they actually work quite well here. They have references for preliminary rulings as that which we talk about, and they keep on talking about that. You can say that the whole text is centered around that. All the sentences are about what is it, and every explanation starts in the references and then says something about how it works, more or less. And either that or takes its point of departure in the Court of Justice. And work with that, but you can very well see this text as an explanation of the term. So you have this idea of saying this is the term. I'll tell you what it's about. So in that way, they include the receivers. As I said, it's mainly the second level of complexity is mainly causal powers. It says something about what causal powers are exercised by the court, and what causal powers does the process of reference have upon the citizens of Europe and the development of the EU. So those are the two central things in this connection. Distinctions the distinctions are mainly made from the point of view of the court. So it's very much court oriented. It's court focused that you have in this. If you look at it from the level of complexity, you can say I would say if I read through it and also read a later passage which says something about the process as such, then you have complexity, but it's of a different kind. It's complex because it's detailed. So you keep on saying this happens with that, and that is the cause of that, and so on and so forth. But you don't give any background. You just go deeper down into the process. So we get to know this is a very complicated process, but we don't get a complex explanation. We don't get a background explanation. We don't get anything like why is it so? Why does this come in or that come in? So and the trick about that is in that way you give people information, but you don't really educate them, I would say, because you stay at a kind of a superficial level in this case. That was the same, yeah, exactly. Then they've also done something else. They have on their website. They have. No, it's up here. It doesn't matter. But up here on the institution, they have it the same way, a long list. One of the lists is press and multimedia. And if you go in there and press on that, then you get access to 4 videos that are explanatory. I think we should just have a quick look at it.
The European Union is an organization based on the rule of law. This means that the countries and institutions that make up the EU must abide by the rules they collectively agree upon. But when they can't agree as to what those rules mean, or whether the rules have been respected, who decides? In all democratic entities, it is the judiciary that performs this role. The Court of Justice of the European Union is the judicial body of the EU. Based in Luxembourg, it ensures that EU laws are respected and applied in the same way throughout all member states and institutions, our benefit as citizens. If a dispute arises concerning what EU law means or whether it is valid, it is the Court of Justice that clarifies the matter. If, for example, a national judge is unsure how to apply European Union law, the Court of Justice is there to help them and give preliminary rulings on what EU law means, allowing the national judge to proceed with the case. In these ways, the court ensures that we as citizens enjoy the protection of EU law in exactly the same way throughout the whole of the EU. Justice for 500 million people, guaranteed by the Court of Justice of the European Union.
Somewhat different, isn't it? I've analysed through this and looked at some of the things that are different here in order to see. I mean, when I saw it the first time, I thought this is just really bad, really low level. On the other hand, if you look at it from the point of view of popularization, this is actually repopularization. What they do is, for example, they start out, they focus upon the role of a court in the system. They say, we want to have rule of law. How can we have that? You need to have a body that settles disputes, which is normally the judiciary, and that is what the court is. So it's positioning. It's not just saying we are the court. It's saying the court comes about because it has this position in the system, and in that way you actually reach the third level of complexity, not in detail, but in quality, because you don't just say this is a court and you just have to accept it, but you say why do we have a court and what is it an equivalent of, so to speak. You have focus upon the relevance for citizens. That's stated 3 times in 1.5 minutes. That's quite a lot to say this. We are here for you, so to speak. Which, as far as I can see, hardly. Well, it was in the other one too, but it's more hidden in the other one. That was the one. You have illustration as dominant. You don't have any written text. You have spoken text, and then you have pictures picturing what is said. So you illustrate the process, meaning you have more modes supporting each other. You have the book as a metaphor of law. So it's a law book, and that book is there all the time. You have the perspective from outside the court, which is also a difference. I just had looked at that. In the first text, it says, or in the text on the website, it says, to ensure effective and uniform application of European legislation, you have the concept of reference for preliminary ruling. So very much. I look at it from the side of a system. There is something we want to achieve, and in order for that, we need the references. Here it says, if a national judge is unsure, then he can ask the court, and it would give a preliminary ruling. So the focus is from outside in. You can say this takes it seriously to say we actually need to communicate with people who don't necessarily think this is important. So I have to tell them why it's important. So focus is different here. You go from general to specific. If there's a dispute, then the court clarifies. And then, as an example, you have if national judges are unsure, the court can give preliminary rulings. And then you have PR-oriented motto at the end, which comes in all the 4, as far as I remember, saying justice for 500 million people guaranteed by the Court of Justice. We are here to protect you, so to speak. So it's speaking to people in a different way. Hence, you could say, with this type of text, the court seems to take the task of popularization more seriously, and actually emphasizes its place in a system and its value and relevance rather than just explaining its own procedures in more detail. So you can say there's a difference here. It was quite interesting. I'm fairly sure. I started to look at this website 2 years ago. I'm fairly sure that 2 years ago this part wasn't there. The other one was there, but this wasn't there. So it looks as if somebody is trying to push something in, but on the other hand, it's really hidden. You need to look for it to find it. They don't go out with it a lot. So, if you sum up the analysis, the website has an emphasis upon its role as upon the court's role as judiciary, not on development. That's actually a difference if you compare with the website of the European Parliament. They emphasize very much that they have developed over time. The court doesn't. The court says we have this role as judiciaries, and that's it. You have emphasis upon their own powers concerning the causal complexity. You have emphasis upon powers and procedure in considerable detail. So detail is important on the website. And you have a dominant focus upon the perspective of the court. And then you have the radically different approach in causal complexity and in focus and in detail in the other one, which is much more oriented towards doing that other part, so to speak, towards also making an image go on. This is the second last slide. The whole idea, and also getting back to what we saw before at the beginning, the Commission saying that why should we write in a way that is more accessible? We should do that because we can create goodwill in that way. That has to do with trust and trust generation. It's one of the ideas that are behind it, and it's probably also the reason why the court has now started to see, okay, we may have to do something. Maybe, although a court in any case doesn't really need it. Any court is in fact instigated and put into a constitutional form. So the Constitution guarantees that the court has its powers. So it could actually just say it's okay, we do whatever. But modern administrations know that doesn't work that way. We have to do something to do something. I think that both the two types of communication we've seen here are there in order to try to generate trust. But they do it in different ways, and you can say behind this lies probably the idea of Luhmann to say you generate trust through acquaintance. It's easier to trust something that I can understand and that I know of, and I think both the two texts try to make accessible to say something about what is it that is going on inside our institution, and the important discussion I think could be to find out which of those two can work in this connection, and which of those two can work in what context. Because probably in some contexts the first one is better because it gives more the authority kind of thing, whereas the second, the multimedia, really down to earth one, could have a problem in actually gaining the kind of authority that they want to. So there are things to work with in this. I think both try to achieve the same, to do something on the trust level in what is going on. I think also that both demonstrate traits of the content of legal culture behind this, but they focus more on inside and outside aspects in this. And I think that could maybe be one of the places of overlap with some of the things that we work with here. Thank you very much for your attention.